We all love a bit of sunshine, don't we? Whether it's reading by the window, working in a naturally lit office, or simply enjoying a bright living room, natural light makes a house feel like a home. But what happens when that light is suddenly blocked by a neighbor's new extension or a looming development next door? Hello and welcome to Blackstone Solicitors. Today we're shedding light, quite literally, on one of the most curious corners of property law in England and Wales: your right to light. Now you might be thinking, surely I have a right to sunlight. Well, not quite. The law doesn't guarantee you sunshine, but it does protect your access to natural light through something called an easement. A right to light is a legal entitlement that allows a property owner to receive natural light through defined openings, usually windows or skylights. If your property has enjoyed uninterrupted light through those openings for 20 years or more, you may have acquired a legal right to that light under the Prescription Act 1832. So, what does that mean in practice? Let's say your neighbor decides to build a 2-story extension that casts a shadow over your kitchen window. If that extension significantly reduces the amount of light you receive, and you've had that light for over 2 decades, you might have grounds to challenge it. But it's not just about any light, it's about sufficient light. Courts use something called the Waldron method to measure whether a room still receives enough daylight to be considered usable. If more than 50% of a room receives less than 0.2% daylight, that could be an infringement. Now, before you rush off to file a claim, it's worth knowing that the law tries to strike a balance. Developers have rights too, and planning permission doesn't automatically override your right to light. That's why disputes often end in negotiation or, if necessary, legal action. In some cases, courts may award damages, financial compensation for the loss of light. In more serious cases, they might issue an injunction, forcing the developer to alter or even demolish part of the structure. But that's rare, and usually reserved for extreme situations. So, do you have a right to light? If your property has received natural light through a window for 20 years or more, and that light is now being blocked, then yes, you might. But every case is different, and the law is complex. At Blackstone Solicitors, we specialize in property disputes, including right to light claims. Whether you're a homeowner worried about a new development, or a developer keen to avoid legal pitfalls, we're here to help. Thanks for watching. If you found this video helpful, give it a thumbs up, subscribe for more legal insights, and share it with anyone who might be facing a right to light issue.